Hello. Today I'm going to talk with you about research I've been doing with several colleagues, which is analyzing how employment arbitration compares to court litigation in terms of the degree of favorableness of outcomes to employees, the speed at which cases proceed, the monetary awards that are provided. As you may know, the use of employment arbitration is particularly controversial in the United States. Critics argue that the mandatory employment arbitration is both unfair to employees because it doesn't provide due process protections. Employers commonly choose the arbitrator. And they also point to research, much of it done by our dean, Alex Colvin, and some of his students, among them Mark Goff, now a former student of Alex, a professor at Penn State, and others who have analyzed questions similar to the ones I'm going to talk about today. Alex and his students find that when you look at the cases that fully proceed to a decision by a judge or an employment arbitrator, that in those cases, employees fare better under court litigation than they do under employment arbitration. They fare better in that they win a higher percentage of cases, and the monetary awards are more favorable to employees. They're higher or larger in employment arbitration versus the awards are larger under court litigation provided to employees in verdicts by a court rather than an employment arbitrator. Well, in any case, the research I'm going to talk about follows cases with a more prolonged time horizon. We look at cases that get started and may well be dropped by summary judgment or by an arbitrator ruling something similar to the way a court would dismiss a case on summary judgment, or a court might decide on a motion to dismiss. And by following those cases, and those that also among them that do proceed through an actual decision point by a judge or an employment arbitrator, we find that employment arbitration fares much better than is shown by the data and analysis that Alex and his students have provided. And we do so basically for the simple reason that with under court litigation, a substantial share of cases get dismissed by a motion to dismiss or by summary judgment. And those cases, with very, very rare exception, favor employers. It's employers that commonly ask for a motion for summary judgment or a motion to dismiss. And let me just give you some data. Here's the data that we analyzed. We looked at all of the employment arbitrations that were handled by the American Arbitration Association in 2019 and 2020. I should add, these cases were analyzed in detail by Lou Maltby, and Lou has been the driving force between the collection of the data I'll now refer to. Lou's an active arbitrator in the New Jersey area, and with the cooperation of the AAA, Lou did painstaking work reading through those cases. And in some of the work, Lou benefited, as we all did in our project, from advice provided by Mark Goff. We thought it was helpful to have Mark, who's done all this prior work on employment arbitration, provides advice to us. The team that Lou assembled included myself, Dave Sherwin, Tom Kochen of MIT, and Ted St. Antoine. You may know Ted is a renowned legal scholar, now retired but still active at the law school at the University of Michigan. Ted's also an active arbitrator. And we were working with Lou as Lou was developing plans to look through the cases. So in any case, here's what Lou finds. He looks at arbitrations that involve commonly discrimination allegations based on race or gender, disability, national origin, religion, pregnancy, and age. I'm just reading the details to make sure I got it right. And he also looked at some of those cases that AAA handled involve FMLA, retaliation, sexual harassment, Section 1981, wage and hour law issues. And then similarly, Lou provided with data that Ted St. Antoine had helped facilitate from the federal court system, looked at all the federal court cases that dealt with similar issues over the same time period. So we're basically comparing a similar type of case and cases, some of which proceeded through employment arbitration, or at least started in employment arbitration, and others of which started and some ended through litigation. Here's the data. With regard to arbitration, in 2019 and 2020, AAA had, and Lou analyzed, 811 cases. Now, many people claim that arbitrators rarely ever decide cases on pre-hearing motions. That's what I thought was the case. I'm not an active arbitrator, but that's what I'd always heard. Lou finds that a number do get decided on pre-hearing motions. Out of those 811 cases, 323 were decided on pre-hearing motions, and those were all decided in the employer's favor. 488 of the employment arbitration cases went to a hearing. Employees won out of that 488 that did reach a final decision by an employment arbitrator. Employees won 31% of those cases. With regard to court litigation, there were many, many more cases. There's 14,654 cases appeared across the country over similar issues. And here's the startling data. 7,862 of those cases were decided on motions to dismiss, and without exception, they were decided in the employer's favor. 6,378 cases that had started through the litigation channel were decided on summary judgment. Again, overwhelmingly in the employer column, employer wins. It's employers and their advocates who seek motions to dismiss and summary judgment. So out of that 14,000 cases, only 414 actually went to trial and were decided through a trial. And of those 414, employees did win 40% of the cases, 164. So if, as Alex and Mark and others have done, if you look at only the cases that were decided by a full trial and those decided by a full hearing by an employment arbitrator, employees do win more in court litigation. They won, again, 40% of the time in those court cases that went to a full verdict, and they won in 31% of the time in those cases that went to an employment arbitration hearing. However, when you recognize all those cases that were dismissed on motions to dismiss with a court case or summary judgment with a court case or in a pre-hearing motion heard by an arbitrator, employees of the total cases that went through to employment arbitration, whether they were dismissed or went through a full hearing, employees won 19% of those cases. And here's the more telling number of court litigation, because so many cases are dismissed on motions, and those are overwhelmingly, with very, very rare exception, wins for employers. Employees only win 1% of the cases that go through the court litigation channel. So again, the win rate of all cases that start in employment arbitration, the win rate for employees is 19%. Of all cases that went through the path of court litigation, only 1% of those cases are employee wins. It's also true, and others had recognized this, Alan and Mark report this as well, employment arbitration is somewhat faster than court litigation, actually substantially faster depending on the nature of the case, but in some other matters only marginally faster, but definitely faster. Employment arbitration is less expensive because you don't have to hire legal advocates, or the advocates don't have to work as long because the cases proceed more quickly and all. Now, in terms of awards, the data that Lou painstakingly put together is consistent with the findings that Alex, Mark, and others have reported, that when damages are awarded either through a fully litigated case or through a fully settled employment arbitration hearing and case, the awards are larger for employees under litigation than under employment arbitration. The data are that in arbitration, civil rights statute cases, the average, the median award, I should say, the median award was $39,000 for the employees. Under litigation, it was $406,000. Under Fair Labor Standard Act cases, FLSA cases, under employment arbitration, the median award was $24,000 for the employee bringing the case. And a litigated case that, again, went to a verdict, the employees under an FLSA case, median awards were $123,000. So, although employment arbitration does seem to yield higher win rates, is quicker, those are both more favorable to employees. It's less costly to bring the case under employment arbitration than under litigation. It is true that the damages are higher on behalf of employees following the litigation channel versus employment arbitration. This data, this study is written up in a variety of reports that are in process. They're not yet posted on the Scheinman Institute website, but they will be. One is the basic report that Lou Malpai wrote up and reported to the AAA, who had kindly provided him with access to their employment arbitration files. Dave Sherwin and I, with help from Paul Wagner, have written 2 articles reporting on this data, and also we talked more broadly about another channel that provides an opportunity for employees to bring complaints. That's an EEOC case. And by the way, we find that there's very few employee wins and advantages to an EEOC case versus pursuing a case through employment arbitration. Dave and I, with again help from Paul, we also make a number of suggestions. We're not happy with the limited due process that's provided in a number of mandatory employment arbitration procedures, and we provide in our writings elaborate recommendations regarding how due process, a fairer process, can be provided to employees with various suggestions about how employment arbitration can be improved through those changes. So there you are. Again, I just wanted to quickly state the issue, provide a quick summary of the results, and say that the full results and the more elaborate reporting of the analysis and more elaborate reporting of our suggestions regarding how the process of employment arbitration can be improved, that's provided in those papers that I mentioned that Dave Sherwin and I have authored. And again, I also want to call out for the heroic work that Lou Malpai carried out himself in reading through all those AAA employment arbitrations in order to reveal the sharp contrast in the number of cases that get settled through summary judgment and summary dismissal motions under litigation versus cases that don't come to fruition under employment arbitration. My bottom line conclusion is that employment arbitration looks much more favorable than one might have concluded from the earlier evidence that was provided in earlier research, while at the same time there are strong, distinct needs for improvements in the process through which employment arbitration takes place in our country. Well, thanks a lot. Take care.